In the meantime, however, I want us to turn our attention to this, and it really is around the backlog of cases before the courts. This is in particular sexual violence cases. Ngaa Murombedzi is Advocacy Manager at Women and Men Against Child Abuse, and she joins me now. Ngaa, good morning to you, and thank you for your time today.
Good morning, Kathy. Thank you very much for having me, and good morning to your listeners.
Let's firstly begin just with this backlog that is being experienced. What are the numbers and the figures that we're looking at?
I think the recent report, Kathy, indicated that close to 80% of the cases that are before the courts, sexual abuse cases that are before the courts, are not being dealt with. So we're looking in the 15,000 region of a mix of cases, including women and children. And this is in the last year, and it jumped. It was a significant jump, if I'm not mistaken, from around 45% to 80%. Now, this points to two things. Is it that there was no record prior to that and the initial figure is inaccurate, and now we're seeing more of what was already there, or that this is also an exaggerated figure, but also one that is not reflective? So it's really quite concerning that the significant jump points to more than half of the cases being dealt with. It's ridiculous.
When we talk about sexual offences, so what crimes then would fall under these cases that are before the justice system?
That's quite an interesting question, especially because the public needs to understand that it's not only rape. Now, the definition of sexual abuse extends to things like compelled rape, attempted sexual assault, the act of rape itself, historical cases of abuse, and it's quite a long spectrum that goes from an attempt to commit a sexual offense, so touching body parts that are associated with sexuality, so maybe a graze on the breast and the bum, to actually penetrating vaginally or anally, but also the act of penetrating orally or forcing somebody to touch your private parts or any parts of you. So it's quite a broad spectrum.
The difficulty here is that when we look at the state of affairs and as far as these cases are concerned, we don't have a good history or track record of expediting cases of sexual offences anyway. So it's difficult, number one, for survivors to bring matters before the courts. And when they are there, we know that there's a very high rate of specifically rape cases that are withdrawn in the country before even any evidence is laid in those matters.
100%. And I will unequivocally say that the justice system really serves as a deterrent for victims of sexual violence. And this is in many parts, but two very important ones is the sexual violence is quite an aggressive act against the dignity and bodily integrity of whether it's a child, an adult woman, an adult male. But to have to go and relive this for the purposes of seeking justice and then trying to activate the system, which begins by disclosing, say, to a police officer. We have many cases where if you are not believed at the police station, you are mocked or you are ridiculed, or it is attributed to the victim as having played an active part in what resulted in the sexual violence that happened upon them. Now we go back, like you mentioned, we don't have a good history, but that's also allocated to the history of the country. So how were sexual abuse cases dealt with previously? And then there's the morality conversation. Where does the sexual violence occur? You know, it's not unusual to hear somebody say, but it wasn't that bad. Do you really want to go to court? It wasn't that bad. So society is disincentivizing our victims, but when they get to court, it's not the duty of the prosecutor to say, look, because our record in the system is not so good, we are not going to proceed with your case. So there's a big gap where victims are finding themselves trying to navigate personally what has happened to them. For children, it means there is no language for them to understand what has happened. Then we encourage parents to activate the justice system, but we have no control, for example, as civil society, as to who is going to be the recipient of what has happened to this child or woman, because there's a lack of empathy within the system. People who use their own frame of reference as a takeoff point with dealing with sexual violence. So from the historical narrative to the moral narrative to the religious narrative, cultural perspective, social perspective, there's a lot of education that is needed. But when it gets to our courts, the courts themselves seem to not understand how we need to expedite these matters, not only because it's going to help the healing of the victim, but because it's going to increase the confidence that people have within the justice system and its different facets.
The issue of, again, the difficulties that people experience in the justice system, and you describe it really as being a deterrent when it comes to people then feeling that if they bring their matters forward, they will be given the necessary attention. Do you get a sense that there isn't enough tracking of what happens with cases, with sexual offense cases rather, once they are before the criminal justice system, whether by way of investigation by the police or by prosecution of the National Prosecuting Authority?
100%, you are spot on. And I think that's the best way to summarize it. There is not enough tracking. And that means also an element of communication. I give you an example of two cases. One which was finalized in court in November of 2021. And in February of 2022, the mother contacted our organization asking when the next court date was. And I said to her, I'm sorry, I seem to not be getting your question correctly. And she said, the rape case against our children, there was a group of 5 children. And I said, was it not communicated with you that the rapist was acquitted? And she was thoroughly taken back because the investigating officer was not aware that the matter had been acquitted. The prosecution had not communicated with the family, and they were under the impression that they still had to go and give evidence in court. So I don't know how the system is missing the different glitches, but in terms of them being able, from investigation, to be able to track down witnesses, to be able to bring witnesses to court, to be able to ensure that services within court. Second case I mentioned is it's been about 2 years and the intermediary equipment doesn't work in a sexual violence case against a child. And it is unlawful to have to expect the child to keep coming back. And she's under oath. She gave her evidence in chief. She hasn't been cross-examined since August 2021. You know, the psychology behind that, it's really baffling. But if the system itself is not equipped to prioritize victims of sexual violence.
It also sounds to me that some of the challenges that exist between the South African Police Service and the NPA end up influencing then the kind of experience that those who would want to see prosecutions in their matters, the experience that they ultimately have.
Yes. You know, the success of any case leans on the investigation. The prosecution cannot present what has not been brought to them by the SAPS. However, it's the responsibility of the prosecution to strengthen their case. So the if we're going to say how can we improve this, investigating officers and the prosecution have got to work hand in hand. If the prosecution feels one witness is not enough, then a statement has detailed that there were 3 witnesses and they don't call upon the other 2 witnesses or request reports, say, in alternative hearings that were done that could strengthen their case. We find ourselves with a situation, for example, like the Bryanston High School case, where it was a single witness leading evidence in a sexual abuse case, and they relied only on the evidence of teachers and that witness. And yet there was a disciplinary process that was done at the school, and that record was never brought before the court. And, I go so far as to say it may have implicated the accused in the allegations that were before the Alexander court. So if the instruction doesn't come from the prosecution, then we are losing what can be aided by evidence that is gathered through investigation. But if the initial statement that is taken is shoddy and it is half-hearted and there is no details in it, the prosecution can't guess what they might need, because then it means we're coming back to victims and trying to coerce them to create a statement that is strengthened enough to go to court. So what is happening there? Why are the investigations not detailed enough? Rather have somebody say, why did you say it was a yellow-colored big pen, rather than not including that there was a pen at all. Rather have more information, because in the case of victims of sexual violence, they are relying on the court to not abuse them some more. For children, for example, where a parent has not said to a child, you define your sexual organs as a vagina or a penis, then it gets to court that the child said igwai instead of a penis. Then now they have to explain, because the child has no vocabulary. The child depends on the investigating officer and the prosecution to highlight to the court that children under the age of 12 have got no sexual language. Otherwise, we're going to question that, why is the child so sexually aware? So you see where the catch-22 comes. Rather detail your investigation so much and aid victims, rather than to negate on that duty and expect the prosecution to perform miracles.
What do you think the issue is? I mean, is it a case of not having enough capacity on the side of the investigating officers to do thorough investigations? Is it not having enough time to be able to pay attention to that kind of detail?
Your guess is as good as mine, but I would hazard the guess at capacity and training, because the investigating officer needs to understand the purpose of the investigation that they are doing. From taking a statement, what is the purpose of the statement? From allowing victims to speak, but also, equip the victim. When somebody is before a police officer and they have been raped, we have to consider the psychological trauma. They may not recall certain things, and we can't punish them for not recalling at that point, but maybe after 3 months they say, I remember something, and the investigating officer says, well, we can't alter your statement. Now, investigators should be trained. When you're dealing with cases of sexual violence, what do you look out for? What do you ask for? We've had cases where the victim has not been taken to a medical facility for a J88 exam. And that could have been where DNA could have been collected. And that brings us to another issue. So the SAPS in their forensic services also is failing victims, because DNA may have been collected and may have been collected late, and then there's a backlog in that particular department where we're waiting 3-4 years and the DNA is not yet available. And we talk about viva voce evidence in court, and we have to be aware that there are some victims that cannot do that.
We continue the conversation with Ngaa Murombedzi. We're taking a look at the challenge of a backlog of sexual offense cases that are before the justice criminal system. And Ngaa, of course, before we went to the news, you were explaining to us the challenges of capacity and training that you believe are contributing to some of the outcomes we're seeing.
100%. Thank you, Kathy. So as I was saying the capacity, especially in how to deal with victims and what to look for when conducting the initial statements that then go to court, is something that can really be strengthened. So, from a civil society perspective, I would hazard that the department from SAPS to the NPA must collaborate. There's opportunity to collaborate with communities to understand how people perceive sexual violence first. And then when it gets to court, to understand the importance of the glitches that are not being covered. I had mentioned the issue of DNA and viva voce evidence in court. When you've got a child who is disabled, for example, or who is under the age of 5, who cannot speak to the court, they are relying on the strength of an investigation, including DNA evidence, to get them justice. And if none of those two are available, a perpetrator is going to walk and a child is not going to get justice.
I want to know from you, Ngaa, that, often communities have this impression that, and it's not an impression, so it's a prevailing, sentiment that one hears often, that for people who are facing sexual offense crime, like the example you gave us earlier of the young man who had been, was going through the criminal justice system, but ended up being acquitted. And there is this perception that people who are accused of crimes such as rape you'll have the matters before their court, but before you know it, these individuals are back in society without any warning to the families, to the victims that they have violated. What does this do for the perception and the trust that people have in the system? Because yes, it seems like it's one story, but when you have one of many of what is happening taking place in different parts of our society, I think it does influence the extent to which people can believe that the criminal justice system works for them.
100%. You bring up a very important conversation, and it ties in with a lot of victim-centric initiatives that I think can really be put forward by different departments, including the Department of Corrections. I don't know if you followed, there was a case in the Western Cape. The child's name was Tasnay Van Fake, and she was raped and murdered by a parolee who had been released into the community, and they were not aware the man was going to come back in. The rate of recidivism in South Africa is unbelievably high. Whether that is because of I hesitate to say failures, but I can't find another word, but the failures of the correction system, or it is because we are not understanding how society perceives certain crimes and how that influences the Department of Corrections and their decision. That's really something we can debate. But like you said, when you're living in a community and you think somebody has let's not even go to being released from the corrections, you think somebody is going to be arrested because you have reported a crime. Then you go outside your house to go and buy bread, and lo and behold, who is standing next to the spaza shop? It is the same perpetrator you reported. Now, victims are then put into a place where they have to protect themselves. Do they want to continue with the case? Are they afraid that this person is going to retaliate because you reported to them, maybe the police spoke to them, and they said, while we gather evidence, we are not going to arrest, as is the process. Because, an arrest warrant is issued on the strength of the information provided. Now, in the community, you become the person who has raised this alarm, and because the person hasn't been arrested, and because we don't understand the process as the average person in the street, you are now called a liar. You said this happened, this person is still in our community, and why is that? Did you lie? Then we go to during the trial process. The person is on bail, but they've committed rape. How are we granting bail? Then we go to being sentenced. A person is sentenced to 10 years. They're back after 2 years. Victim-offender dialogue has not happened. There is no mediator. There's nothing that has been done. And yet this person is back in your community. You're buying your bread 2 years later. Boom, there is that person. So the perception within our communities, you can't blame people because that's what we are seeing. We are seeing people who are sentenced to life imprisonment being released on parole after serving a ridiculously low sentence time. And we are seeing people not being convicted. We are seeing arrest not being done. We are seeing bail being granted. So, the conversation of we want our victims to activate the justice system when they have been victims of sexual abuse is all good and well as we speak. But how do we implement that? Because unfortunately, Kathy, with 80% of sexual offenses as a backlog, they can't plead as a department that they are making anything work. How do we have only 20% of cases being finalized? What is the turnaround time? What is the recourse for a victim? What must they wait from being abused as an 8-year-old girl until they're 16? How do they move on with their lives? So I think we have to be cognizant of the victims themselves before we want a systemic thing to work by itself. We have to have the voice of the victim. Promise the victim that it's 9 months, and then we get to a point of finalization of the case, and let it be 9 months or less. 6 years waiting for justice because systems aren't working, it's really unfair.
And Ngaa, just briefly, as we get ready to wrap up this conversation then, what is the impact of the challenges that we have seen with the DNA testing at the laboratories? Is that part of the reason why there's this big holdup?
I assume so, Kathy. From our cases in particular, yes, it contributes largely to the delay. Like I explained that in cases of child abuse, where the child cannot identify the DNA has been collected, the court is relying on that DNA evidence. But the challenge seems to be the capacitation of people dealing with victims. And what we see, unfortunately, is if people aren't trusting the justice system, they are going to withdraw cases. Then we have people who are not prosecuted, who are not convicted, going into our societies and reoffending. But it's not a reoffense if you've never, been arrested for it. So what we are seeing is more and more people losing their confidence in the justice system. It doesn't work for them. It's a few cases that we can say